Welcome back to the D&O Diary Podcast series. Today's episode is about tariffs. In early 2025, the focus was on whether the president had authority to impose tariffs under the International Emergency Economic Powers Act. But that issue seems largely resolved after the Supreme Court decided the learning resource case in February of 2026. So, Kevin, why are tariffs still a D&O story?
Well, there's still a D&O story because the Trump administration has made it very clear that it intends to keep tariffs as one of the important tools in its pursuit of its global trade policies. Even after the U.S. Supreme Court's decision in the learning resources case, the Trump administration has subsequently imposed other tariffs relying on other statutory authority. And I think it's clear at this point that the tariffs in some form will continue to be part of the operating environment for companies and will continue to impact their operating results and their financial results with potential consequences from compliance and even private litigation. So I think even though there have been the setbacks in the judicial challenges to the Trump's tariff authority, it is a continuing risk that will continue to affect companies and potentially continue to translate into D&O claims.
And as you mentioned, this is really the administration's priority to lever tariffs. And the administration has not been shy about indicating that it would use the False Claims Act to enforce its priorities. And so we saw on May 12th, 2025, the DOJ, the Department of Justice Criminal Division, issuing its update on a white collar enforcement plan, which elevates trade and customs fraud, including tariff evasion, into one of its top high impact enforcement priorities. We then saw in August 2025 a task force creation. On August 29th, the DOJ officially partnered with the Department of Homeland Security to launch the Cross-Agency Trade Fraud Task Force. This task force combines resources from the DOJ, civil and criminal divisions, the U.S. Customs and Border Protection, and Homeland Security's investigations. And it's actively using the False Claims Act and wire fraud statutes to target non-compliant supply chains. In fact, we saw one of the largest settlements with Perfectus Aluminum for $550 million under the False Claims Act that in May 2026 indicated that the task force had secured this particular settlement from this company that was purportedly using evasive schemes and was importing aluminum from China. So this is an example of kind of how this task force that came together is really focused on levering the False Claims Act for purported tariff evasion.
I think one thing that's important to emphasize for this audience is that those enforcement actions are not solely against public companies, that the targets of those regulatory enforcement actions include not only public companies, but private companies as well. And I emphasize that because I think there's a tendency to think about the tariff issue as only a risk that pertains to public companies or only larger companies. And many of the companies that have been targeted in these enforcement actions, particularly the False Claims Act actions, are private companies, and in some cases, smaller companies as well.
And those types of regulatory enforcement actions involving the False Claims Act can potentially lead to follow-on D&O litigation, correct?
That's certainly true, as is true in many contexts, not just this context. There's the old adage that sooner or later everything becomes a D&O claim. A company that is the subject of a alleged tariff evasion regulatory enforcement action could subsequently find itself facing a D&O lawsuit where investors allege that senior management, the board, failed to fulfill their fiduciary duties or their duties of oversight over the company to ensure the company was in compliance with the tariff policies of the Trump administration.
And Kevin, I know we have recently written about securities class action cases that have a tie to tariff or trade policies. Do you want to give us a couple of examples?
Well, you're right, Sarah, and there have been securities class action lawsuits. Before I talk about a couple of examples, I just want to emphasize that the D&O The possibility of D&O claims as a result of the administration's tariff policies include not only those regulatory actions that we were discussing, but also the possibility of private civil litigation. And the most concrete examples to talk about are the securities class action lawsuits that have been filed starting back in August 2020 right through to today. The first example is a case that was filed just in June against First Solar. It is an example of a solar company that imports solar panels from Southeast Asia. And the allegation in the lawsuit is that the company understated the extent of the impact on its Southeast Asian operations and also understated the impact on the company from its attempts to try to onshore its manufacturing operations in the United States. When it released its quarterly earnings and announced disappointing results, its share price declined as securities class action lawsuit came in. Another example worth talking about, Sarah, is a case that was filed earlier this year against Pinterest, the social media platform, and it announced disappointing financial results, and in doing so, explained the downturn as a result of changed buying patterns by its trading partners, the companies that buy advertising on the website. And what Pinterest said was, as a result of the impact of the tariffs on those trading partners, they were buying less advertising, which had an impact on Pinterest, which is really interesting because it wasn't the impact of the tariffs on a services company that does only operations in the United States, but still was impacted by the tariffs because of the impact on its trading partners, which I think underscores the fact that you not only have the risk of misstatements about the tariff policies, but the risk of understating the operating risk that companies face as their operating partners deal with the tariff policies.
So it sounds like this common theme of the cases that we've seen relative to the securities claims are that the tariffs themselves are not necessarily creating the risk of alleged security fraud. It's the disclosures themselves. So these plaintiffs' attorneys are focusing on guidance, the disclosures, margins, earnings, supply chain, and in the case of Pinterest, how the company should have anticipated that its trading partners might be impacted by the tariff. This sounds very familiar to kind of what we saw with the COVID litigation when it first came in, and litigation that was also related to inflation and companies not being able to determine how to disclose the impact of those external factors.
Yeah, in that sense, Sarah, you're right that those other examples, the COVID cases, the inflation cases, and the tariff cases, they all show how in the current securities litigation environment, any type of operational setback can give rise to securities litigation. You know, I'm old enough to remember when securities litigation used to just be about financial disclosures, especially accounting misrepresentations, whereas now they tend to be about the whole operating circumstances of the company. And these tariff cases are another example of that.
So let's go back a little bit and talk about the court challenges to the tariffs that have been imposed by this administration, beginning with the learning resources decision in February of 2026. That case were challenges that were brought against the Trump administration regarding his authority to have the IEEPA tariffs imposed on China, Canada, Mexico, and other countries. The court found that the president did not have authority without specific congressional authorization to impose tariffs under IEEPA. And then, Kevin, we saw the administration turn to lever Section 122 tariffs, and the International Court of Trade struck those down, correct?
That's right. And it's probably important to emphasize that those Section 122 tariffs were always temporary. And even by their own terms, they would have expired on July 24th. So although that was the administration's immediate response to the adverse outcome in the learning resources case, I think the Section 122 tariffs, that part of the story is pretty much closed. In fact, the Trump administration has already moved on to seeking to use the authority of Section 301 of the Trade Act of 1974 in order to impose a different set of tariffs.
And the Section 301 tariffs seem to authorize U.S. trade representatives to investigate and respond to a broad host of potential issues with respect to the country the United States is trading with. So, for example, unfair foreign trade practices, human rights conditions, intellectual property violations, and then additional remedies can be imposed on those countries, including tariffs. And we've already seen an example of the Section 301 tariffs be imposed and upheld, correct?
Yeah, it's worth thinking about the 301 tariffs because I think this statutory authority, by contrast to IEEPA and Section 122, the president is on much more solid statutory ground. Section 301 does require certain procedures. It requires the U.S. Trade Representative to conduct investigations and make findings. But even the first Trump administration was able to use Section 301 to impose tariffs on China. And so there's much better statutory authority, historical precedent, familiar procedural processes to impose the tariffs. And in fact, as you pointed out, the Trump administration has imposed Section 301 tariffs in the second Trump administration. Just on July 15th, the U.S. Trade Representative, at the conclusion of an investigation, imposed tariffs, for example, on Brazil as a result of a long list of alleged unfair trade practices. I think it's clear that this is the tool the Trump administration is going to use going forward. The U.S. Trade Representative has already initiated a number of other investigations, and so I think it is likely that we will continue to see additional tariffs imposed as a result of the Section 301 process for the remainder of the second term. And I think what that means is that I think we need to assume that the operating companies will continue to need to deal with tariffs and will continue to need to make disclosures about the impact of tariffs on their operations and financial results, which of course in turn means circumstances that could subsequently give rise to securities litigation if the company faces adverse developments in its operations or financial results.
Yeah, and there are other types of litigation that companies have faced as the result of the tariffs being imposed and then struck down. For example, the tariff refund litigation that has stemmed from the striking down of the IEEPA tariffs has resulted in consumer class action lawsuits being filed against a handful of companies, including Sony, Fabletics, and Costco. And the allegations there are that these companies were attempting to pass through tariffs as opposed to absorb them to customers. And that now that these companies are able to be reimbursed for those purported tariffs because they were struck down, the companies may be kind of double dipping. And so we're seeing these consumer class actions being filed, and it would be interesting to see if the consumer class actions might themselves lead to litigation that may have an impact on D&O underwriters.
Well, there certainly could be the kind of follow-on litigation that we mentioned before. And again, another illustration of how sooner or later everything can turn into a D&O claim. But the consumer actions themselves would not be D&O claims. Those are consumer practices type lawsuits. Certainly an individual case might name an individual as a defendant, but that would be a circumstance in that individual case. But by and large, these consumer lawsuits are consumer actions of the kind that typically wouldn't trigger the D&O insurance policy. And so they're important to know and understand, and certainly what disclosures the companies make about either the refunds they're seeking or any follow-on consumer actions will be important to monitor and could theoretically lead to securities class action lawsuits down the road. The refund actions and the consumer actions themselves are not going to trigger the D&O insurance policy, all else equal.
Right. They just serve as kind of another example of tariffs creating secondary litigation consequences. And you know what, Kevin, I think it's important as we consider the types of litigations that may stem from tariffs that are being imposed and struck down, really what the whole geopolitical risk landscape looks like right now. Tariffs are just one part, correct?
I think that's important to emphasize. We talk about the tariffs because, first of all, we have the recent regulatory enforcement and claims examples, but also because it's such a high-profile issue right now in the United States. But Geopolitical issues have been a source of D&O risk for years, and there have been, over the years, examples of D&O lawsuits that have arisen because of geopolitical factors, like, for example, trade sanctions and export controls and anti-money laundering policies. And I think both of us have written about those types of issues. So though we focused on the tariff policies, we shouldn't lose sight that the tariff policies are part of this larger area of geopolitical risk.
Yeah, often it's trying to work around those sanctions that could get a company in trouble, especially if a regulatory agency has focused and determined that a company has attempted to evade sanctions. And especially with the ongoing conflicts that we've discussed, it's becoming more challenging for companies to operate. And so there may be opportunities for organizations to, again, potentially attempt to evade certain rules, regulations, and sanctions. And we've seen that with litigation tied to certain cryptocurrency exchanges. And so I think that geopolitical risk may also force companies to take actions that they may not have before to ensure that their revenue remains stable.
And the disclosures about those actions as well. Pattern of allegations in a trade sanction evasion lawsuit is an allegation that the company said that it was compliant or that it had procedures in place to ensure that it would not violate the sanctions. And then the subsequent allegation is there were revelations that the company had not put sufficient controls in place or even was actively seeking to evade the sanctions. I think the important point in the context of this podcast is there are varying kinds of geopolitical risk affecting the D&O environment, of which tariffs are just one example.
And so, Kevin, given that tariffs are the one example that we're focused on today, what comes next for boards, management teams, and brokers, knowing that tariffs are here to stay and the geopolitical landscape continues to remain more uncertain than it has in the past?
Well, you made the point yourself, which I think is the most important one, which is the tariffs are here, and we must assume that is the insurance underwriters, the investors, operating companies should assume that tariffs are going to continue to be part of their operating environment. And that obviously has implications for the company's disclosure practices and also for boards and as they fulfill their obligations to ensure regulatory compliance and to oversee operations in a way so that the company isn't exposed either to tariff or sanction evasion allegations or to securities class action litigation or other type of investor litigation that could turn these geopolitical risks into D&O claims circumstances.
So the tariff debate, which began as a fight over presidential authority, is really now for D&O practitioners, underwriters, brokers, and then companies that are trying to determine this risk. How will tariffs require disclosures? What will governance and enforcement issues look like moving forward, knowing that these tariffs are here to stay? I think that's really kind of the biggest takeaway today.
Yeah, you're right. I mean, one takeaway is clearly that at least for the balance of the Trump administration, it should be assumed that tariffs are going to be put in place and functioning as part of the administration's overall global economic policies. A couple of points I want to pass along in closing. The first is just to reiterate something I said before, that the risk from the tariffs is both for public companies and private companies. And I think it should not be overlooked that this is a risk for private companies as well. One last point is I think there may be a tendency for practitioners to assume because the court struck down the prior Trump administration tariffs that this is a problem that has gone away. And, I just refer back to the First Solar case that I mentioned earlier. That case was filed after the Supreme Court's Learning Resources case and after the Court of International Trade struck down the Section 122 tariffs. So the risk of D&O claims arising out of the administration's tariff policies has not gone away, notwithstanding those judicial decisions. And I think that D&O underwriters in particular should assume that the risk of D&O claims as a result of tariffs not only is continuing, but is likely to continue for the balance of the current Trump administration.
Certainly considerations that, we all need to keep in mind going forward. So we want to thank you, our listeners, for joining us today on our podcast regarding tariffs.
Thank you, everyone. We appreciate your time and attention.